Hello, kids. Welcome to the Fearless Floyd Show. I'm your host, as always, Fearless Floyd. You can always reach me at TheFearlessFloydShow at yahoo.com. Subscribe to my channel. Hit that like button for this video. Hit the notification bell. If you want to know when I post new videos, leave a comment below. Try to answer everything. And as you see, my gorgeous background on an overcast day on Tuesday, 1/11/2022, in the awesome Houston, Texas. And today's topic, uh, because I did my little bogus letter out of North Carolina, people send me stuff. My viewers, my fans, my subscribers, uh, my frenemies, my enemies. Yeah, y'all send me things. So, in part of that sending me some stuff, I received another letter. And apparently, this one is from a Pennsylvania state representative who is no longer in office to a state judge for a they consider a petty offense in Pennsylvania for speeding, doing 65 and a 45, and driving with a suspended license. So he sent me this letter, and of course, I perused it and did my little Fearless Floyd's investigation. And I just want to share with y'all what this is because maybe y'all have seen this letter before, maybe you haven't. Let's see where it's at. I don't see it there. So let me, there we go. And we can share. Okay. This is a letter that was sent to me. Move that out of the way. See up here, it was issued by, apparently, allegedly, let's clean that up, Samuel E. Rohr, who's a member of the 12th, 128th Legislative District in Harrisburg, Pennsylvania. This is his district office. These guys have multiple offices. Over here are the committees. So I looked these up, and some of these committees I didn't see that he was a member of, or the chair or whatever. Now, one of the things that caught me was that right there. Okay, that P running into that Commonwealth. You see the distance in the gap here. So right there off the bat, that's close, but it looks like maybe a copy and paste. And it just didn't fit. Second thing, the April right here, a little high up here in the header. So that was a red flag. And of course, this symbology is not very clarified. And in that, right here, the seven's missing. There's just a lot of little inconsistencies that I look for. I'm not going to say I'm a master forger. Uh, but I know somebody who is. So when you look at it, some of these things just don't quite um, add up. And the style right here to the addressee is not proper because this would actually say Honorable Phyllis R. Stridle, comma, Judge presiding or presiding judge for the Chester County Court of Common Pleas. Okay, so right there you can see the difference. There's no reference in here, again, that tells you what this letter is going to be about right from the jump street. So, no indentation in the paragraphs. They're all squared up, justified, as it's called. So, when I read this letter, this is the person that's about right here, this Mr. William Taylor Reel, and that on March 26, 2006, Mr. Reel apparently knew this legislative member, this representative, for over a decade and came in there and apparently, allegedly, explained everything to Samuel. Sam was like, "Oh well, I really don't know anything about the law, so let somebody on my staff who is an attorney look at it and make a determination, and we'll get back with you." And apparently, according to this letter, a member of the staff did agree with Mr. Real right here that everybody has a right to travel, and you don't need a driver's license. Okay. So it says right here he's found guilty of violating two provisions of the Transportation Code for Pennsylvania, which I already explained. So you know him for 14 years right there. I believe Mr. Real has a better understanding in this area of law than many licensed attorneys, which, having researched many cases and read countless appellate briefs and petitions for discretionary review and rebuttals and traverses by licensed bar attorneys in the state of Texas, that's not a stretch statement right there, folks. Some of these motherfucking idiot bar licensed attorneys have absolutely no business litigating in a sandbox, much less a court of law or a for-profit corporation, which we already know that that's what they are. So that's my little spiel on that. So anyway, it goes, my staff member researched this conclusion right here. Let me, on my mouse. Okay, reached the conclusion that Mr. Real stands on solid legal footing. Okay, so I'm reading this. Okay. What do we got here? So he goes on and on and on and on and on, and talks about this, and of course it's got his signature on here, which could or could not be legit. Could be a copy and paste. Now, right here, this is the designation for actually who prepared this instrument for Samuel E. Rohrer, but generally this is a / and not a colon. So, of course, that raised another red flag for me. Is this a genuine document? Maybe. However, generally, there's something down here in the footer, and there's nothing here. So when you're dealing with government stationery, there's generally something down here, or they're going to put page number, at least a page number, because this is 2 pages. So I see an omission that possibly could announce this document as a fraudulent document. So I could have left it at that and got on here and done it. Says, oh yeah, it's I've debunked it. It's bogus. Has no validity. Don't pay attention to it. But of course, me, I'm Fearless Floyd. I'm going to get to the bottom of this shit. Okay? I don't care what I got to wade through. If I got to fight off the flies, I'm going to get in that shit and I'm going to fucking root around and we're going to have a good time. And I'm going to find the answer. Okay? So I'm willing to get in the shit and fucking go. So let's see where I went. Fair enough? All right. Whoop-de-doo back over here so I can share the screen and show you what I found. Come on. All right. Now this is just U.S. law. Okay, right here you can see that no bullshit. You can go to that link yourself. So I did a search for Samuel E. Rohrer, looked up his information, and did a pretty thorough background check, which just is available on the internet. And maybe he could have wrote that letter. It's a possibility. I even went to the Pennsylvania Legislative Archives and looked in there. Yeah, I went deep down that rabbit hole. So this is a non-presidential decision, not to be confused with presidential, which means it has no precedent, okay? No holding, no authority, okay? That's what that means. It's a Superior Court IOP, inter-office, probably that stands for inter-office policy, I guess. All right. This is the Commonwealth of Pennsylvania. They're the appellee in the Superior Court of Pennsylvania, which is, I guess, the highest court versus William Taylor Real. He's the appellant. There's a number. Appeal from the judgment of sentence entered January 12, 2015 in the Common Court of Pleas in Scully Hill County Criminal Division at numbers, and that's the case number. This is before Allen justices, probably. Yeah, probably justices, not judges. Allen, Ott, Strasburger, memorandum by Strasburger, which means Strasburger, for this three-person panel, wrote this memorandum, right? Decision. It's either, yeah, memorandum right there. Okay, my bad. All right, so it's filed July 31st, 2015. All right. William Taylor Real, appellant appeals pro se, which means he did not have an attorney. He did all this through self-litigation. From the judgment of sentence entered October 11, 2013, following his conviction for the summary offenses of driving while exceeding the maximum speed limit by 20 miles per hour while driving while operating privileges are suspended or revoked. After review, we affirm appellant's conviction, vacate his sentence, and remand for resentencing. So let me break that down for you. So his conviction for speeding and operating a vehicle with a license suspended or revoked or expired stands. His sentence of, I believe it was 90 days in jail, vacated, removed, taken away. So the court remanded back to trial court for him to be resentenced under new law, because while his appeal, which was pending, so whenever you appeal a case, it's not a final conviction until you exhaust all your appellate remedies through in Texas, your court of appeals, one of the 14 courts of appeals. If it's a criminal case, the Court of Criminal Appeals. If there's constitutional error, you'd go to the Texas Supreme Court. Okay, but generally it just goes to the Court of Appeals and to the Court of Criminal Appeals on a criminal conviction, and that's a wrap. That's a final conviction. So while he was pending on appeal, any law that changes would affect how the court is going to rule on his grounds of error on appeal. Okay? And I'm using all the proper terminology, so listen and learn. I've done all this. All right. The trial court summarized factual background of the case from the de novo trial held on January 12th, 2015. De novo means anew, basically, in Latin. So they looked at it with new eyes. All right. And I can't make this shit up, kids. Listen to this. The Commonwealth presented testimony from Pennsylvania State Trooper Paul Hardknock. I can't make it up. Hardknock. So Trooper Hardknock, not to be confused with the University of Hard Knocks. Basically, so this is the same story that I was telling you, that, he started following this Mr. Real and found out that he was driving 20 miles over the speed limit. They presented a certificate of speedometer accuracy for the trooper's vehicle and determined that it was accurate and that, yeah, he was speeding, going 65 at a 45 mile an hour zone. And then when the trooper pulled him over, asked him if he had a driver's license, he said no. And through the license plate on the vehicle, they were able to trace it back and find out that, yes, Mr. Real had a driver's license, still had the contract, but it had expired, and he had multiple offenses for driving with a suspended or no driver's license. So basically, this just goes out and breaks it all down, blah, 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 what happened. So they sentenced him right here to a $1,000 fine and 90 days in the Scully-Kill County Jail pursuant to the statute. Appellant took the witness stand in his own defense and on cross-examination admitted that he was operating an automobile on September 12, 2014, and that he had no driver's license on the day in question. Now, I'm going to tell you the same thing these judges will tell you when they admonish you when you elect to go into a litigation without counsel by self-representation. Okay? And there's an admonishment that they are legally required to walk you through to make sure you completely understand exactly what you're doing. And I'm trying to remember the case off the top of my head that requires him to admonish you. And it's not Strickland and it's not Chronic. I'll remember it probably before we go. If not, I'll put it down in the comments later. But yeah, there's a case that they have to use to admonish you to it, that you knowingly, willingly, voluntarily waive your right to counsel, and you understand the proceedings, and that you are your own worst enemy, and that if you get up on the stand and you admit anything under oath, that you are compromising your Fifth Amendment right to not give testimony against yourself, opposed to the Article 1, Section 10 of the Texas Constitution. Because I'm in Texas, not Pennsylvania, I cannot be compelled to give evidence against myself. So I don't even have to give motherfuckers a driver's license or my passport or anything, because I have rights. Anyway, that's how it works in Texas. So he appealed the sentence to a flat term of 90 days incarceration and a $1,000 fine. He timely filed notice of appeal. They had two errors in here. Blah 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 blah. Basically, they cite the case in here, but I wanted you to read this that they cite as a Supreme Court case. The movement of motor vehicles over the highways is attended by constant and serious dangers to the public. Damn deer. And is also abnormally destructive to the ways themselves. Unquote. That's Hendrick versus Maryland, 235 U.S. 610 at page 622. Decision date or decision year 1915. And of course, I think we've evolved in the last 107 years. However, that U.S. stands for United States, and that is a Supreme Court case law. So these type of cases from the Supreme Court can be cited three different ways. You're going to see the U.S., and that's a different volume from, let's just say, 100 S period capital S period capital C lowercase t period, which stands for the abbreviation for the Supreme Court, and then of course it'll have the page number. So there's two different volumes there. You have the U.S. volume and you have the Supreme Court volume, and then you have the lawyer's edition, the LE D. So generally the lawyer's edition is different. You don't have to order it. You don't have to cite it. So a lot of people cite, all three of them. You don't have to do that. You can pick one or, one of the three. Let the lawyers use the lawyer's edition. You use the U.S. or the Supreme. I like to use Supreme Court because it tells you right then and there. That's a Supreme Court case. Anyway, that's my own take on that. So I wanted to read that to you, so you kind of understand what they're going to throw at you if you find yourself standing on the square and they're trying to push you off and they're throwing this stuff at you, that you have a rebuttal to it, because that's what you're going to need. Anyway, so to make a long story short, they vacated. They upheld the conviction, vacated the sentence because another case came along um, during the pending of the appeal, because it wasn't a final conviction, so he's still eligible in case the law changed. Whether there was appellate case law, post-conviction case law, or legislative case law that enacted and made things different for the elements to be sentenced. All right, so that's basically what it goes back here, and we agree with the trial court that appellant's flat sentence of 90 days incarceration sentence is illegal pursuant to this court's holding in Post D. Therefore, we vacate appellant's sentence and remand to the trial court to resentence appellant to a sentence that complies with 42 Pennsylvania criminal statutes, section 9756A. Convictions affirmed, judgment, sentence vacated, case remanded, jurisdiction released, which means they sent it back to the trial court. Now the trial court has jurisdiction over the case to bring him back and resentence him. Okay, and here's the Postee case, and of course it has a footnote 4. Here's footnote 4. The trial court applied the new case law appropriately where, as here, appellant's case was pending on direct appeal. See Commonwealth versus Cabeza. I'm not going to do the site. Quote, where an appellate decision overrules prior law and announces a new principle unless the decision specifically declares the ruling to be prospective only, the new rule is to be applied retroactively to cases where the issue in question is properly preserved at all stages of adjudication up to and including any direct appeal because the conviction's not final. There you go. Which they didn't add, and I just did. Because I've been there, done it many times, not only my own litigation, but for others. Okay? I keep telling you guys, man, I'm published in the books. I've had cases remanded, I've had them reversed. Fuck, man. I've argued, yeah. I've been there, done it. Fearless Floyd has been there, done it. Count on it. I just proved to you I know what the fuck I'm talking about. Don't challenge me on that, guys. I'm telling you. So basically what we have here is a questionable document that has some red flags to it. A little disingenuous, but it could be legit. I doubt it very seriously it's legit, because if a real licensed bar attorney in Pennsylvania on the staff for a legislative representative, I doubt would very seriously side with a defendant with multi convictions, because in the history you can go back and read that. You can look it up yourself. This gentleman had prior conviction. He actually had 6 convictions for operating with a suspended or revoked or expired driver's license. So me, first thing, if somebody handed me this material for this guy, I would go look that up right off the bat. Is this guy legit? Does he got a legit beef? He doesn't. He's trying to circumvent. So the first mistake he made was not surrendering his license. He just let it expire. The contract was still valid because he never rescinded the contract, never rescinded the signature, never gave it back to him, tell him he didn't want it, preserve his rights, apply terms and conditions on it. Go see my video on surrendering your driver's license, okay? It's all very simple, okay? License plates, that's how they caught the ding-dong. License plates, they ran his plates, boom, his name popped up. There's the connection, okay? You got to surrender your plates. You got to surrender your registration. You got to surrender everything. Look, I don't want it, man. I don't want to play in y'all sandbox, man. Y'all throw sand in my eyes and shit. Get it all in my ears. I got to take a bath. Fuck them, man. Fuck their system. Get out of it. So if you know how to get out of it, and you want to get out of it, and you want to operate lawfully on the land and soil, you need to know what the fuck you're doing. And all this, these letters floating around that are questionable, I'm trying to answer the questions for all that. So anytime you have something that you want looked at, investigated, vetted, send it to me. I'll take a look at it. If it's something worth doing a video on, I'm going to do it. And with that, kids, like the video. If you want to contact me, I'm at TheFearlessFloydShow at yahoo.com. Hit the comments below. Subscribe. Hit the notification bell wherever it is. I can't see it. Subscribe to my channel and share. Share, 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 share. Turn everybody on. Make them smart. And I have a call coming in. Thanks for watching. Appreciate it. Love you guys. And I'll catch you on the next video. Adios.